Hey, you alright? This is a recording of a webinar we did back in December 2025. I've just finished processing it. We only actually ended up doing half of what we planned to do because it took so long, so there is going to be a part 2 of these slides. But basically it's just me and Will going through some basic terms just to help people understand some of the jargon that gets thrown around there. If there are terms that we don't go through that you think would be useful for us to cover at some point, just stick it in the comments because I might well do a part 3 at some point. But it's just there to help people understand some of the language that gets used and to understand a little bit in a kind of very shallow sort of level of detail as to what these different terms mean.
So yeah, let's get through it as quick as we can. So we've got an hour and 15 and there's like 120, or how many slides are there? 151 slides. So we are going to be like rattling through this as quick as we can. Let's get started. So primary legislation, I'm not going to read out the slide. I'm just going to talk very briefly about it in kind of part, and will interrupt me if things come up. So primary legislation is basically your acts of parliament. So things like the Housing Act, 1996, Homelessness Reduction Act, things like that, which is, if you've ever actually tried reading, is quite difficult to get your head around, and there's lots of kind of gaps or ambiguities. So that's kind of what we're talking about when we talk about primary legislation. That sets out the rules and the principles that the law will follow, but it in no way will be comprehensive. There will always be questions which are unanswered in the primary legislation. Priority need being a good example, actually, which doesn't actually define what vulnerability really means. We've then got secondary legislation, which, as you can imagine, is kind of where the government tries to fill in the gaps. A good example of secondary legislation, there's a lot of it, obviously, things like statutory instruments, which go into a lot of detail, but a good example would probably be the domestic abuse statutory instruments that came out in around about 2012, because domestic abuse kind of developed quite rapidly, if you think about it, over the last sort of 15 years or so, going from where, we actually had to physically be hit to actually be subject to abuse through to, our understanding today. And what you generally, that's a good example, you find is that the statutory instruments and the kind of suitability, the guidance around that ended up coming into chapter 21 of the Code of Guidance now. So a lot of the wording remained the same. So you'll kind of see how they bring in secondary legislation, and then that ultimately ends up either in statutory guidance or actually kind of ends up as law itself. England, just to make this point as well, the types of the laws we're talking about today, Housing Act, social care, things like that, they are specific to each territory. So there is quite a lot. Well, there's a lot of crossover between England and Wales around housing law, but there, where we get to Scotland and Northern Ireland, it departs quite markedly. So, although in many cases, and in fact, the textbook we get by Jan Luber, so Housing Allocation and Homelessness, it covers England and Wales because there is so much overlap. Scotland and Northern Ireland are completely different beasts. So, it just kind of works very differently there. And we are coming from the point of view of being in England, so this is what we're focusing on today. Local authority, again, this might really seem pretty basic, but it's just good to kind of start with this stuff. So local authority is your local council. Now, some areas have a 2-tier council system where, for example, you've got your local district council and then you've got your county council, and it matters because essentially the district council is responsible for discharging duties under the Housing Act and so on, whereas the county council will be in charge of discharging duties under things like the Care Act. So it's much more straightforward in one sense to work and live in a unitary authority where everything's under one roof. But there are still plenty of 2-tier authorities out there. It seems like there's a big shift towards a unitary authority system in England, but that's kind of what we've got. And I'll come back to that as a little bit in terms of councillors and public meetings and stuff, because actually that is very relevant to homelessness as well. Power versus duty. Most of what we see in the Housing Act, or certainly the bits we care about the Housing Act 1996, are duties. They're things that councils have to do. I talk extensively about Imam v Croydon from a few years ago, where basically Croydon tried to say we don't have any money, and the judge said that's your problem, get to it. There are a few instances within housing law and homelessness law where we have powers, and effectively powers are things where a council has some discretion about how it basically discharges that power, if that's the right word for it. But even then, you'll see that there's actually quite a narrow framework as to how they can utilise those powers. So, for example, when you challenge a decision, a negative, let's say a non-priority decision, and you go through the Section 202 process, and these are all terms I'll use later, there's not a duty to house you at that point. However, there is a power to house you, and case law basically dictates that if you've provided some kind of new information which is more than trivial and you've asked to be housed, then the council must house you. So although it's only technically a power, the way it works in practice is it kind of feels a bit like a duty, really, because there are these very clearly defined things within case law which can be lent on to then get the council to actually house someone. Discharge of duty is just when the council's got a duty to do something and it goes and does it. Happy days. It can do that. It can do it lawfully, which is when it follows the law. It can also discharge duties unlawfully, which again we'll come back to in a little bit. Rights are things that it's very fascinating how rights have developed over time in England. But basically, a lot of the bits of legislation we talk about today, so Housing Act primarily, but also things like the Care Act, the Equality Act, Data Protection Act, they all confer rights for people in this country, not even just citizens. Actually, could, in some cases, anyone would be protected by these different bits of legislation. And so, in one sense, a good example of a right would be the right to make a homeless application. You can always do it. It will often result in varying degrees of kind of levels of duties that would be owed to you, but you always have a right to it. Things like the Data Protection Act, there's a right to a private life, which the Data Protection Act 2018 will protect. So these are things which come out of the law, which I would say make the country work properly if only we actually bothered following it. So yeah, I would say personally, mine, going on a bit of a tangent briefly, I believe we are best able to end homelessness by seeing homelessness as a rights-based issue, because there's loads of rights that people have under housing law and other bits of legislation, and they're very effective at getting people housed if only we dare to actually challenge a council to make them actually follow it. Evidential threshold. Housing law and these other bits of social welfare law come under civil law rather than criminal law. And what that basically means is generally councils will be assessing approaches on the balance of probabilities rather than the idea that you've got to prove beyond all reasonable doubt that someone's owed a duty. So this is kind of why we see lots of thresholds under housing law and homelessness law as being low. In terms of, for example, the local government social care ombudsman has made the point that someone who reports that they're subject to domestic abuse should be believed without a good reason to doubt them. So yeah, a lot of councils kind of seem to operate from this idea that you've got to prove beyond a reasonable doubt that you are homeless before they even look at you. That's definitely not the way it should be done. This is all low threshold stuff, really, or relatively low threshold, I should probably say. And there's a difference between the council having reasons to believe that you might be homeless versus being satisfied that you are homeless. So that's something to also bear in mind in terms of how this kind of works. So yeah, burden proof is kind of related to this. In most cases, there are one or two exceptions, but 99% of cases, the burden of proof is on the local authority to establish what duty is owed to someone. So in theory, you should not need to know anything about homelessness law. You should be able to stumble into a council and basically tell someone, I'm homeless, can you help me out? And it would then be on the council to carry out inquiries, to make inquiries, adequate inquiries, and actually arrive at the decisions that, relevant decisions that are going to be owed to that person. So there are some duties tucked away within the Housing Act. Just to give an example, things like the protection of property, actually the council's has various duties. One of the things they should specifically be inquiring about when someone makes a homeless application is whether that person needs assistance in protecting their property. That is something I've never seen a housing officer actually do, but it is there within the law. So there are plenty of other things as well. But it's the council's, the council's supposed to be the one which is there to help you. And should volunteer useful information. In fact, if I just go down a couple of slides, I'll come back to it because we're going to talk about advice and assistance in a little bit as well. So, yeah, just kind of bear that in mind in terms of burden of proof. In most cases, there's one exception I can think of within intentional homelessness and acquiescence, but that's the only one I can think of where the council doesn't have to kind of figure out something itself and kind of side with the applicant. Housing Act 1996 is the kind of primary bit of primary legislation that we care about, specifically Part 6 and Part 7. These are things, again, we're going to come back to several times more in this webinar. But Part 7 is the part of the Housing Act 1996 which is all about homelessness. There are obviously 5 other parts that precede these things. I've never even read it, so I don't know what they're about. But if you want to get housed, if you want to get help getting housed, both Part 6 and Part 7 are going to be your friends. Part 6 basically applies to people who want to apply for social housing, who are not homeless, and Part 7 applies to anyone who wants to get help with housing when they are homeless. We've seen a number of bits of legislation which I haven't listed all here, but I've kind of picked out the most important ones. The Homelessness Reduction Act 2017, which came through in 2018. Basically, that introduced things like the relief duty, the prevention duty, the personalised housing plans, duty to refer. You will notice it is not reduced homelessness one bit. Homelessness is now at record levels. And I'm not going to go on from one about why that is, but basically, I would say that the HRA entirely misunderstood the root causes of homelessness. So rather than ensuring that there's adequate supply of housing, they made a whole fuss about making sure people get a plan to work towards, which most people don't need that plan to be able to get housed, but that's another issue. Yeah, so as I say, I could talk all day about that. But Children Act 1989 will come in when you've got a household or a family with children involved. Also, you'll have homeless 16, 17-year-olds, or in theory, younger children who are homeless and aren't part of a family or whatever. So that does happen still. No, it's not the Children's Act. It's just the Children Act. So, if you want to get pedantic and stuff, just worth bearing that in mind. But there's a whole load of stuff within the Children Act which overlaps with the Homelessness Housing Act and homelessness various bits of law. Because let's say, for example, you have an intentionally homeless family who've got children. Those children, we're British, we're not going to allow those children to be on the streets. So if the Housing Act 1996 doesn't come to our help, then the Children Act will kind of act as a safety net to ensure those people will have some support. Just to say, I'm not going to say it extensively here, but it's actually quite difficult to be legally intentionally homeless. So a lot of people are told they are when they're really not. But the Children Act does act there to make sure that children are not left homeless. That process is rough, though. Don't get me wrong. It's not like it's you're not going to get put in a palace somewhere. It's going to be hard work. Domestic Abuse Act 2021, really good legislation overall. Probably some bits which maybe could have been a bit better, but generally speaking, it's really good. The theory behind it is I think it's a good example of where the people who wrote it had a lot of had a really good understanding about what the issue was that underpinned it. The problem with it is really just the fact that the councils don't have enough money to follow it, unfortunately. So if you're willing to challenge a council and get them to follow the law, there's a lot of support available to survivors. But there's still plenty of cases, thousands of cases every year where people who are very clearly owed duties under the Domestic Abuse Act and kind of bits in the Housing Act which kind of overlap are left in harm's way. Renters' Rights Act 2025. As I've already said, I certainly don't know much about this yet because I've avoided the headlines. I just wanted to wait to see it actually working in practice. There is some bits of it have already happened. Most of it's going to happen next April, and there are some other bits which will happen later in the kind of maybe 26, 27. Equality Act 2010. Again, really good bit of legislation. Not enough money to actually follow it from central government. But it's relevant to housing situations because if someone has let's say a disability, then a council has to be incredibly careful about how it considers that disability and the effects of that disability when it's then discharging other duties to that person or that family. So you'll often see, even within a standard section 184 notification, again, excuse the jargon, you're going to see a whole a few paragraphs probably which are basically dedicated to establishing if someone has a disability and kind of what the extent of it is and what needs to be done as a result. So something to be aware of as well. Care Act, again, a lot of crossover here. The LGSCO, the Local Government Social Care Ombudsman, has quite frequently criticised both adult social care and the housing team because both departments had a duty to someone and neither of them actually did much. So things like safeguarding duties, adult safeguarding duties, Care Act assessments are all kind of contained within the Care Act. But it's relevant again because technically speaking, if someone approaches a housing, homeless person's unit, whatever, and it appears that they may have care and support needs, then that council, assuming it's a unitary authority, they have a duty to carry out a Care Act assessment on that person, and very few housing officers have ever even heard of it before. So but again, it can be very helpful when you're working with people with complicated needs. It's a really good way to get some more information, if nothing else, in terms of the assessment, and that can then inform how you help that person. Mental Capacity Act 2005 again is relevant to homelessness situations because if someone's mental capacity is in doubt, it can potentially prevent that person making a homeless application. Although again, it's not something that councils have a lot of, if any, training about it. And so you'll often see it misunderstood. You'll see someone with a diagnosis of a mental health issue and they say, oh, you don't have mental capacity to make a homeless application, which is completely the wrong way to read it. But it does kind of absolutely overlap with the Housing Act and homelessness duties. And then I think there's the final bit so the final bit here, so Data Protection Act, my favourite bit of legislation, believe it or not, because it is so good at making organisations, particularly councils, actually genuinely consider the interests and the kind of wishes of a person. who, we often kind of hear person-centered support being shouted about for a service when really it's not person-centered at all. But you can use the Data Protection Act to make a council actually genuinely listen to someone. So I use it quite a lot, and also things like a right of access. You can make a subject access request to get all your records. Those kind of things are also bread and butter for taking a council and challenging them. We'll talk about briefly the courts here. So county court. I'm going to try and avoid. In fact, I'm not going to read the slides out because that's just tedious. Will, could you give us an assessment of the county court in 2 sentences?
It's the more junior of the courts, and you've got the High Court and the County Court, but it's where most of the sort of day-to-day work goes on in cases that aren't specialist.
So things like anything to do with the homeless application presumably would probably go there first. Is that about right?
Yeah, I mean, having said that, the Administrative Court, which is the High Court, deals with judicial review, which deals with a lot of homelessness stuff. In fact, it deals with so much stuff that they had to change the law in 1996 to make sure that at least some of it went to the County Court, which is why you get homelessness appeals in the County Court rather than the Court of Appeal.
My understanding is that if there's like an urgent situation where, for example, a council is gatekeeping someone, then you'd be going to the High Court for judicial review.
Yeah, there's a list of council decisions that are open to challenge by way of, first of all, a Section 202 review and then a Section 204 appeal. And because of that, you can't generally go to the High Court and judicially review the council on one of those decisions. But there are lots of other ones which fall through the net. So a refusal to process a homelessness application at all would go for judicial review. A refusal to provide interim accommodation under Section 188 would be judicial review, and so on. But there's a load that still go to the High Court. It's difficult sometimes. You can get caught out because you think you think you can go for a judicial review, and then you find you should have gone for a review. So it's worth just double checking before you start any action.
I think I've got a reason why I think I understand these bits. So if something doesn't get resolved at county court, it would then go to Court of Appeal, if I understand correctly. Am I roughly right there, Will? So
largely, yeah. I mean, the High Court has got some limited appeal right sort of role from the county court. So it might go county court, High Court, Court of Appeal, or it might just go straight to the Court of Appeal. I've never quite figured out when and why that is.
And I just realised we didn't do introductions, but Will is a very, very experienced solicitor. So yeah, just kind of goes to show how convoluted this process can be.
Yeah.
But I mean, Court of Appeal is the second highest court in the land. So generally speaking, if a case gets resolved at the Court of Appeal, it's going to be legally persuasive and weighty. Whereas something in a county court, and this matters because you've got cases around vulnerability and priority need, which are really good cases, but they're only county court judgments. So, like for example, Thomas v Lambeth. Whereas Court of Appeal, if something's settled there, then it's going to basically be authoritative. And then if you go one stage further past the Court of Appeal, you get to the Supreme Court, which, as it suggests, is the highest court in the land. And again, some really important cases like Hotak, which settled the question. Well, they didn't settle it, but they kind of talk about the question of vulnerability. They were Supreme Court cases. We've mentioned briefly their judicial review already, so I'm not going to go over it again. Case law, we talked about primary legislation earlier. But there's obviously a lot of gaps when they set it out, lots of kind of loopholes that need to be figured out and sorted out and ironed out. Case law is the idea that when you have an argument which involves some kind of ambiguity, the argument that happens in court, for want of a better word, kind of becomes the law. It's unfortunately it's never kind of when the judges write these judgments, they never they don't seem to kind of try and make them as helpful as possible for people to understand. So to actually understand the case, you could potentially have to read the entire judgment and then figure out which bits the judge means and which bits they don't mean, because both sides of the argument will be put forward. But we'll see kind of really important things around suitability and vulnerability all established within case law. There's loads of other examples. A really good resource, which I'm not putting the slides here, is a website called Bailey, Bailii, British and Irish, something. But basically, there's a lot of transcripts of court cases. Not every case is kind of uploaded, but a lot of them are. That's a really good resource to understand, actually to kind of read the actual full judgment. And it can sometimes be the only way to understand a particular issue because it does go into so much detail. Statutory guidance. So we're talking here, well, I might be wrong here, but I'm pretty sure every piece of legislation will have some kind of accompanying statutory guidance that goes with it. So for the Housing Act 1996 Part 7, it's the Homelessness Code of Guidance. And that is essentially telling councils how to interpret the law. So although it says guidance, it's not just kind of, do it if you feel like it. It's basically saying you must do this unless you've got an exceptionally good reason not to. And as we saw in Imam v Croydon, not having enough resources isn't enough of a good reason. So in fact, I can't think of a case where a council got away with not following the guidance. It's written in layman's terms. It's probably the best single resource you're going to find to understand the law. Pretty sure every single bit of legislation will have accompanying guidance that goes with it. Certainly the ones we're talking about today. So the domestic abuse guidance has the domestic abuse guidance framework. And kind of the Data Protection Act has various bits on the ICO's website, which is also statutory guidance. So if you're going to start looking at what the law is, searching for Homelessness Code of Guidance is going to be your best first step, I'd say. Maladministration is where a council fails to follow the right process. It's not so much about the actual decision. So it might be that decision and someone's not in priority need isn't something to do with maladministration, but it's more about, did the council accept a homeless application when they should have? Did they provide interim accommodation when they should have? Stuff like that. Did they just delay things? The LGO website, the LGSCO website, which I'll come to in a minute, basically logs every single decision that they've kind of made, or certainly nearly every decision they've ever made. And the most common kinds of failures are simply just delays in accepting an application in the first place, inadequate, or not necessarily inadequate inquiries, but not providing interim accommodation, delaying with the complaint process, not providing records when they should have, all of those kinds of things. And if maladministration goes on to cause someone injustice, which is quite likely really, so if you fail to accept a homeless application, that leaves someone homeless, then that is almost certainly going to be something which causes injustice, which can be compensatable through the LGSCO. And let me go back to actually talk about the LGSCO, just to explain. So it's basically a kind of a service for lay people. You don't need to be a solicitor to access it. In fact, I would imagine the majority of people who access it won't be solicitors. And they investigate complaints that they've already gone through the council's complaints process, and they recommend compensation. Although, as I've said many times, the amount of compensation they provide or they recommend is less than what it would cost to house the person in the first place. So councils know that they can essentially break the law, get caught, and pay a bit of compensation, and there's not a huge amount of problems that then causes. Similarly, so let me just go back a step. So the local government associate ombudsman investigates basically various council departments, social services, housing, planning, those kind of things. You've then got the housing ombudsman, which investigates social landlords, whether it be council landlords or registered social landlords. We're going to see, as I say, I've not been following the Renters' Rights Act, but there's going to be another ombudsman, there's at least one more ombudsman for private rented accommodation. Now, they can't technically tell a council what to do, but the vast majority of councils will follow the recommendations. So recommendations aren't just compensation. It might be, get your staff trained, change your policy, those kinds of things. So if you're serious about ending homelessness, you need to be engaging with the ombudsman if you're not kind of taking cases to court, because that's an effective way to get a council to improve its standards if you're doing it consistently. So that's kind of and I guess certainly my experience with the ombudsman is they're quite friendly and kind of they realise they're working with lay people. They're not expecting you to know kind of every little bit about the law. They just want you to kind of have a rough idea of what you're talking about. Just talk about compensation. So this is a link here which takes you through to the local government associate ombudsman's guidance and remedy. So they kind of explain how you calculate how much compensation to give. Advocacy is a bit of a kind of an ambiguous term, I think, to some level, because it can mean different things in different settings. When I'm talking about advocacy, I'm talking about a lay person helping someone who, let's say, is homeless, and you're trying to get the council to follow the law. In terms of who can be an advocate or who can act as an advocate, there's a useful case here from the LGSCO, which is kind of this question where a lay person was essentially trying to help his friend and did a really good job there, but the LGSCO said that actually there was a limit to how much he could do on his friend's behalf. Whereas an organisation like a charity who's got policies in place, safeguarding policies, that sort of thing, would be able to get much further with that process. And you've also obviously got kind of specialist advocacy services as well. But I'm probably talking about something a little bit less than a kind of a dedicated advocacy service when I talk about it. Housing authority. I've talked about local authorities before, and as I've said, housing authority is basically the council or the district council which has a kind of a housing options service or housing service. But the important thing to understand is they're run by elected members called councillors, and I would argue that a councillor has a lot more power than an MP. Some people might disagree with that, but certainly when it comes to making a council function properly, an MP doesn't have any formal authority over a council, whereas councillors actually do. So again, if you're serious about ending homelessness, you need to be engaging with councillors, you need to be educating them about what's really happening, and you need to be attending these kind of public meetings. So, kind of again, as the slide kind of says what I've just said here, you certainly, a good counsellor can do a huge amount of, make your life a lot easier. In many cases I've worked in Bedford, a case has been resolved because a counsellor got involved and they kind of pursued it and were persistent and they got it sorted out without having to go through court and stuff like that. Finally, in terms of this kind of section, public meetings, again, because councils are part of a democratic system, they have open public meetings, which they must allow members of the public to be able to ask questions and comment on things. Again, if you're serious about any homelessness, you need to be getting to your local councils, because that's where the action happens, really. That's when decisions are made, which will decide how much money the council's housing options team have, how much money they have for temporary accommodation, what kind of temporary accommodation they have, all those kinds of things. What quality is it? Do they have specialist accommodation for people with particular needs? All of that is set out in your public local meetings. Unfortunately, most public meetings, no one ever turns up. It's just the councillors, and they love it because they don't get held to account. But if you've got a little active group in your area, going to your local council, it can be a fantastic way to actually get things shifted and get things improved. So that's the section about general kind of legal principles. We'll now talk about part 7, as in the homeless application process. And again, it's not obviously in alphabetical order here. I'm just trying to kind of give it some sort of logical order. But homelessness strategies are something which councils must do every 5 years. And again, if you're serious about ending homelessness, every time it comes up for renewal, you need to be dedicating some hours to providing robust, informed feedback to your council. You might say, oh, it's, what's the point? Councils just do what they want. And yeah, they kind of do if you let them. My experience of homelessness strategies in Bedford, last time we had one, or last time it was actually a consultation about the housing register. We asked for 16 things to be changed, and we got 15 of them. So, if you know what you're talking about and you're willing to kind of actually, inform yourself, you can get a lot of good from this sort of thing. Things like, what kind of temporary accommodation is needed by the council? Is there enough temporary accommodation for people who need a wheelchair? All of these kind of things will be up for grabs in the homelessness strategy, and anyone can input into them, and again, you can use public meetings to amplify the messages you're putting through. So yeah, that's the homeless strategy. And just to say that on this as well, this essentially puts an anticipatory duty on councils to actually have enough suitable housing for their constituents. So if a council says, oh, we don't have enough housing, that's their own fault, because they're going to have a homelessness strategy which made sure there was enough housing. So it's kind of, really, it's just an admission that they didn't do their job properly last time the homelessness strategy came around. And there's other kinds of strategies, like a housing strategy, like a local plan and stuff like that, which will have a bearing on this sort of thing as well. So kind of, you want to be, I guess, kind of like literate around these kind of opportunities that will come up from your local council. Homeless persons unit, aka housing options. Every council probably calls it something different, but this is the service which is essentially primarily responsible for ensuring the council adheres to the law around the Housing Act, particularly Part 7. Although a lot of councils will structure their service so that people, the officers who are dealing with homeless applications will also be dealing with housing register applications. So there will be crossover there. And although, as we'll see in a minute, you can make an application to any department of the local authority, if you're sensible, you want to be approaching your local homeless persons unit, for one, or whatever it's going to be called, because they're the staff whose job it is to discharge the council's duties. In terms of the definition of homelessness, again, you can talk all day about this sort of thing, but essentially, our very definition of homelessness comes from Section 175 of the Housing Act, 1996, and really, there's three kind of criteria. People who don't have a home, the obvious ones. People who have a home but they can't get to it or can't access it because it's been nicked, or it's been it might be a caravan that's been stolen, or it might be that the landlord's illegally evicted them, or where someone's got accommodation but it's not reasonable to continue to occupy through things like domestic abuse, unaffordability, unsuitability in terms of medical conditions, all of those kinds of things. Again, you could talk all day about this sort of thing, but that kind of just sets our stall out in terms of what homelessness actually is. Because when you ask most people what's homelessness, they'll think about somebody who's rough sleeping, and actually that's just the tip of the iceberg. The vast majority, there's an example, there are far more homeless children in England than there are people sleeping rough, and yet you look at the media, they're always talking about rough sleepers. That is beginning to change, I think, which is good. You've also got this idea of threatened with homelessness, which is essentially where it is likely you're going to become homeless within the next 56 days. And essentially, if you are homeless or threatened with homelessness, you can make a homeless application. And there are two criteria which you have to meet. one, you have to ask for help with housing in some way, and secondly, you have to provide some kind of evidence to give the council reasons to believe that you might be homeless or threatened with homelessness. And when I say provide evidence, saying you're homeless, that's evidence. It doesn't have to be like kind of a kind of some kind of written proof or something. It's a very low threshold, and it's designed to be low to ensure that people get help. So yeah, it's not when the council get around to processing your application. The application is made the moment these two criteria are met. Gatekeeping is not technically a legal term, but it's essentially where a council unlawfully denies housing to someone. Usually it's through things like telling someone, oh, you've got no local connection, you need to go somewhere else, or you're intentionally homeless, there's nothing we can do, or you're not in priority need, there's nothing we can do. It can also happen inadvertently because the IT system doesn't work properly. So that's actually quite common. You'd also probably use the term gatekeeping to include situations where someone has made a homeless application and it's been accepted, but they haven't then been provided interim accommodation when they should have been, because again, it's a low threshold. So there's a report, and again, something I put in the slides here if I had time, is the report the LGSCO did about 10 years ago. It updated it, looking at gatekeeping specifically, but most reports about from the LGSCO will include something about gatekeeping because it's so common.
Mike, could I jump in at this point?
Yeah.
I just like to say gatekeeping is a wider thing as well. I'm sorry if you were going to. I got to it before you said it. There's the most obvious instances of gatekeeping where somebody is sort of told false information and then they don't make a homeless application. But the gravitational pull of the way that all homeless applications are dealt with tends to be with a view to gatekeeping, in the sense that the council's staff are trained to see their role as to restrict the amount of accommodation they give out rather than to sort of encourage people to come and take it. So the interpretation of all of the rules is done with a view to saying no. So, for instance, if somebody says, I'm in priority need, I've got a medical condition, they'll say, oh, no, it's not serious enough. And then if they can't get you on that, they'll try and get you on, oh, well, you made yourself intentionally homeless. And if they can get away with that, they've saved a property. So you may get a blatant piece of gatekeeping, but then you may get a more subtle form. So you should never think, I mean, I'm not trying to say that all councils operate in bad faith, but they do to the extent that they're not actually trying to help homeless people. They have a statutory duty to do it, but in the way they discharge it, they're tending to look for excuses not to do it, if that makes sense. Or their management are. A lot of the people on the ground floor, I'm sure, are doing it for the right reasons, but somebody looks at a spreadsheet and says, hang on, we gave 50% more accommodation away last month than we did the month before. What's gone wrong? Rather than what's gone right. Thank you.
Yeah, that's really cool. Thanks, Will. I think as well, I mean, I can't remember the case now, but I read it recently, which basically made the point that housing law is there to house people, not house people. And what gatekeeping does, if nothing else, is it sweeps the problem under the carpet. So although the housing manager might be thinking, great, we've saved a bit of money there, they've just stored up a problem for them down the line. It doesn't kind of, gatekeeping people doesn't solve anything. It just kind of keeps people in a state of despair and homelessness. Notifications, just basically written documents, either sent by email or in person in theory, which set out a council's decision. Now, not every single decision a council has to make has to be in writing, although most do. Probably the single most important one that doesn't require a written decision is actually the denial of interim accommodation, because your council doesn't need to make a decision about that as such. Gets rather complicated, but in most situations, when a council makes a decision to accept a relief duty or discharge a relief duty or accept the main homeless duty or deny the main homeless duty, then the council will need to put that in writing. That letter can often be 10 pages long. I think we all saw one recently which is about 80 pages long, something ridiculous. It will be a template, so the housing officer who wrote it probably won't understand what they've written. And again, a little bit like Will described, the template will basically shoehorn officers into not accepting a duty rather than accepting a duty. So if you actually if you're willing to actually kind of engage with it, it's generally not very difficult to challenge. But most people just see a lot of legal jargon and they think, oh, that this must be right. It probably isn't. So part of that notification will need to explain to someone how they challenge it through the review process. So again, one of the, going back to gatekeeping, a very common situation is where someone goes into a council, the council says you're not in priority needs, but they don't give it in writing. So there's nothing that person can then do to formally challenge it. So the first bit of work to do there is to get the council to issue something in writing. We've also got this kind of slightly unusual, kind of weird sounding idea of homelessness at home, or homeless at home, sorry. And that is where someone is legally homeless, because they might be, let's say they're sofa surfing, and their friend, their friend can kind of let them stay for a little bit longer, but not long term. And so they make a homeless application, and it might be that the interim accommodation duty is owed, but that person would prefer to stay with their friend in the short term because it's nicer than temporary accommodation. And assuming that that person is happy with that, then that's kind of okay. And if that relationship then broke down the line, then they can reapproach the council, and the council's duty to provide interim accommodation would kick back in again. The problem you've got is that housing officers will often say to the friend, oh, if you don't let him stay tonight, he's going to be on the streets. And that's not true, because the council has a duty to house them. So actually, in fact, I'll try and avoid tangents right now because I've just seen the time. But yeah, just kind of understand that there is this idea of homeless at home. It certainly has a negative potential impact, because if someone stays out of temporary accommodation, then they're more likely to be forgotten by the council. Council will look at who's costing them the most money and focus on those cases. If you're staying with family or friends, you're not costing the council anything. They are not motivated at that point to make inquiries in a timely fashion and kind of actually do anything about it. So there's a good case, if you want to see more about that, called Edwards v Birmingham, which gives you an example of how it works in practice. So, but yeah, it's a term. It's sometimes misused, I think, or kind of misunderstood. But I think that, in fact, I know that's what it's really talking about, is where someone kind of makes their own arrangements for the interim accommodation, and that's okay if everyone's happy. Rough sleeping, it's not illegal. Legally, there's no differentiation between rough sleeping and other forms of homelessness. But there is this definition out there which will be used for things like the rough sleep account, which is essentially someone's rough sleeping if they're either outside or they're sleeping in a building or vehicle that's not designed for human habitation, so in a car or something like that. As I say, legally, it's not a thing. It's not a distinct thing, but it's a problem because we have the verification of rough sleepers, which can, again, be a kind of way of gatekeeping. Before we get there, briefly, just to talk about cuckooing, because cuckooing will often result in that person legally being homeless, even though they have a tenancy. And cuckooing simply where someone is targeted, probably because of their vulnerability, and essentially another person or a group of people will take over their premises and use it for some kind of illicit purpose, or even just live there and kind of take all the person's money. It very quickly becomes homeless because it's not reasonable to continue to occupy that accommodation. Verification of rough sleepers, I just mentioned it, just to say that whilst the verification of rough sleepers exists, it's a thing which a lot of charities are involved in. It's not legal in the sense that if you walked into a council and said you're rough sleeping, can you get some help? You've actually made a homeless application. If a council then tells you to go and sleep rough so you can be found by the rough sleeper outreach team and then get support, that would be gatekeeping. That would not be lawful. So if I was rough sleeping, I would completely bypass the rough sleeper team and just go straight to the council, to be honest. So yeah, rough sleep. Yeah, these street outreach teams are run by charities often, but often there will be some kind of partnership working, very close partnership working with the local authority. And again, some of these slides I'm not quite sure where else to put them, but you may, in the course of your interaction with homeless people, hear about IT systems like Chain or Inform or Jigsaw, My Home Options. These are just IT systems that councils use to process personal data, and they can be used for different purposes. So sometimes, your homeless application is kind of pushed towards the IT system. That's not technically legal either, but in most cases, it's just probably worth going with the flow. Duty to refer. So certain statutory bodies like probation and prisons have a duty to refer. Just to make the point, again, 18.9 of the Code of Guidance makes this point very well, or 18.7, one of the two, 18.7 maybe, basically says that a duty to refer does not actually trigger a homeless application. So this is really important because lots of professionals make a duty to refer and they're then surprised that the council doesn't do anything. The reason nothing's happened is because a homeless application has not been triggered. So just kind of understand that if you are working for one of those statutory bodies, you have to do the duty to refer, but you then also need to make a homeless application in order to maximise the housing options available. Statutorily homeless, or statutory homelessness is again, this might be something which people correct me on, because I've seen this term used in ways which I don't think is really what they're talking about. My understanding of this term is that someone is statutorily homeless if they meet the legal definition of homelessness, and it's that simple. However, I've seen charities or even kind of big charities talk about this term in terms of people owed the main homelessness duty, which I don't think is what it means. So again, I'll be interested to see if anyone's got any better ideas than I do. But yeah, it's just kind of this idea that homelessness is a statutory issue. In fact, it's a legal issue, And in the same way that when you sell a house or you buy a house, you want to get a solicitor involved, you want to get legal representation. If you're homeless, ideally you want to get a solicitor and get legal representation, although that's probably far more difficult because of the lack of funding. But yeah, it just kind of underpins that homelessness is a legal issue as much as anything else. Household is simply the homeless person or the homeless family who's making a homeless application. And just note that we have this term called single homeless, which can be a bit confusing because a couple without children would be considered single homeless. It's just kind of essentially it's households that don't have an automatic priority need characteristic, and even that's a little bit clumsy because I'm not quite sure whether that would include people who've been made homeless through things like disasters. I actually don't know, but certainly single homeless people will be people who are essentially relying on vulnerability to show priority need rather than having children or having a pregnant woman in the household. Offences are making a homeless application, so it's a criminal offence to knowingly or recklessly mislead a council to get them to house you. There's some interesting little bits here and there, but generally speaking, it's going to be obvious. It's where someone is literally just making something up, or they're kind of neglecting to tell the council that they actually have accommodation available already. So yeah, technically you can get prosecuted for it. There's a little bit more nuanced stuff around where a council has the burden of inquiries lies with the council. So the question is, at what point do you have to kind of do the council's job for them? If you've told them, let's say for example, that you've got serious health issues and they kind of ignore that, is it then on you to pursue them and say, I've got health issues, you need to take this into account, or do you just kind of shut up and wait for the review process to start? But yeah, I guess the sensible thing to do here would be to err on the side of caution and provide any information that might be relevant. Protection of property is something I alluded to it already. You'll see it detailed in chapter 20 of the Code of Guidance. It applies to a wide range of homeless people, not just people in priority need, and it applies where someone is unable to kind of protect their belongings themselves or store them, whatever, so the council essentially have to step in. Again, I'm just kind of touching on it here, not got enough time to go into any detail. Advice and assistance is an interesting one actually, because under Section 179 of the Housing Act 1996, councils have a duty to provide competent advice to anyone in their district. And that what basically means is if you get into a conversation with a housing officer and you explain, you've got mortgage arrears or whatever it might be, one of the things they should tell you, one of the things they should volunteer is, oh, you can make a homes application. I say this because often that doesn't happen. In fact, the actual opposite happens. But just to say that if you wander into a council and you don't actually ask for assistance in the right way to trigger a homes application, they should be volunteering to tell you how to do it. That's kind of part and parcel. Whether that's a big part and parcel of their job is to kind of recommend homes applications and kind of discharge duties accordingly. Eligibility. So eligibility within the homes application process is really looking at something akin to recourse to public funds. So basically certain people from abroad are excluded from getting housed under the Housing Act, although just to say you can always get advice and assistance. So if you are not eligible for assistance, it's still worth making a homes application just to see what advice and assistance you might get. It might be you get a bus ticket back to Poland, so it's not always going to be what you want, but it's something which can be done and it does increase options. Priority needs, we have not got anywhere near enough time to talk about it here. In fact, I do a whole day's training about priority need, kind of going into a fair amount of detail. There's some good videos on the YouTube channel, so check that out. But essentially, if you are in priority need or you might be in priority needs and you're eligible, then essentially what that basically means is a council may well have a duty to put a roof over your head. In fact, it will do. I'm being slightly clumsy here. If you're not in priority need, the council does not have to put a roof over your head. So although there are other duties, they often don't actually amount to much in the real world, which is why priority need becomes such a battleground for homeless applications and making sure that making sure people actually get the assistance they're owed. And it's effectively why councils are often so apt to downplay vulnerabilities and kind of try and find a reason not to house someone, as Will kind of said earlier. So there's loads of resources. There's like 20 videos on the YouTube channel about different aspects of priority need. Now, interim accommodation, which is also known as emergency accommodation, it kind of comes from Section 108 of the Housing Act 1996, and it is owed to anyone who may be homeless, may be eligible, may have a priority need. So again, it's a low threshold, but interim accommodation is essentially the accommodation you get from making an application and meeting those three criteria. And either the council being satisfied you're not in priority need, or you're not homeless, or you're not eligible, or the relief duty runs its course and the council makes a decision that you're owed the main duty or the Section 190 duty. If you are new to homelessness law, everything I just said there won't make sense. I apologise for that. There's a webinar we did back in June or July, which was going through the homeless application process. This is like a flow chart I did. So we go through in detail about all these different stages. But just understand that interim accommodation is that emergency accommodation someone may well get when they've made a homeless application and they meet certain criteria. The important one again being reasons to believe that you might be in priority need. Temporary accommodation is then the accommodation you get after that decision has been made at the end of the relief duty. And you may remain in temporary accommodation for 20 years if you're in London until you actually get your final home. You can lose it, obviously, if you don't follow the rules or you refuse it. So, again, the advice should always be to someone who doesn't feel accommodation offered is suitable is to accept it and then challenge the suitability rather than taking the risk and kind of doing it any other way. Bed and breakfast accommodation. Now, you might think this is a bit of a weird thing to have in jargon, but bed and breakfast accommodation means something specific within the law. And we get it from, I can't remember what it's, chapter 17 of the Code of Guidance, but essentially it's privately owned accommodation where you share some of the facilities. So there's rules around how long a family with children can be kept in B&B, which is 6 weeks. There's other things to say about it. Young people should not be housed in B&Bs at all. Again, legally, it matters with the nuts and bolts of that decision because, technically speaking, if it's not privately owned, let's say the council owns it, you can use the B&B accommodation, even though it's shared, for indefinitely, really. So the devil's in the detail with this sort of thing. Intentional homelessness is essentially where the council is satisfied that you have lost your last settled accommodation through an act which you should have known could result in you becoming homeless. So, yes, somebody goes to prison, doesn't intend to be homeless, but they did do something intentionally which should have foreseeably left them homeless. There's quite a few mitigating circumstances which we won't go into here. We did a webinar a couple of months ago about this sort of thing in a lot of detail. But just understand that a lot of people who are told they're intentionally homeless actually aren't. Local connection. Part 7 differs from the Part 6 definition of local connection, even though they use the same terminology, which couldn't be more confusing. The definition is on the slide there, so I'm not going to talk about it in detail here. Again, we've done quite a lot of stuff on the channel about local connection. But effectively, if you make a homeless application to a Council A and you don't have a connection to Council A, but you have a connection somewhere else, and it's safe for you to live in that other area, then the council can refer you under Section 198 to that other area. They don't have to. It's a power rather than a duty, going back to that terminology. But they often will. Effectively, once that happens, Council B will be the one who is ultimately responsible for finishing that homeless application with you. Section 202 review, we talked about briefly already. If you get a kind of a bad decision at the first stage in terms of a Section 184 decision, you can challenge it. You've got to do it within 21 days of receiving the letter. And at this stage, you can basically you can pretty much attack anything within the reasoning of the letter. If you think the council's decision is wrong, you need to explain why it's wrong, and it will be dealt with by a more senior officer and hopefully result in a better decision. Lay people can do that. You don't need to be a solicitor to do that. But it does require a little bit of care and attention to actually make sure what you're writing is relevant. So you need to kind of have a basic understanding of what it is you're arguing. If that isn't successful, the next stage is the 204 appeal. But this gets rather technical in the sense that your argument needs to be on a point of law rather than the actual facts. It's a really weird thing. I mean, you will be able to do a better job than I can explaining this. But it's not actually a question of was the original decision right or not. It was, are there some technical points of law that were kind of wrong about that initial decision? Will, I don't know if you want to say a bit more about this.
Yeah, I mean, I could go on about this at some length, but what I would say is that it's got to be an error of law. So you can't say I'm not happy with the decision, but you have to say I'm not. I think that, or sorry, the best way to think about it is like doing a math. If you're doing maths at school and you're doing some sums and you're writing them down, and the teacher will be looking not just at the way you got the answer you came up with, but the way you got to it. Another way of thinking about it, if they make a really bad decision, it's probably got an error of law in there somewhere, because you can't decide that somebody who's really ill is not vulnerable without making an error of law. And that could just be that you fail to properly apply the definition of vulnerability. So I normally don't have very much trouble thinking, oh, well, I disagree with this decision, but I don't think it's an error of law. So don't be too put off by that.
I mean, and you'd hope it by this stage, although technically you don't need a solicitor, in the real world you do.
Oh, yeah.
So in one sense, the solicitor would be the one worrying about the point of law rather than you. But I mean, I guess there's an argument to say that it kind of matters how good a job you do of the Section 202 review earlier in the process, because you want to make sure you're actually kind of touching on the important issues in the review process itself. So minded to letter is essentially a draft decision in the Section 202 process, where the council tries to give you an additional opportunity to kind of put them right. Councils also use minded to letters in the section, before they even reach a Section 184 decision, which is a bit interesting because they don't have to do that. And a cynic would say that what they're trying to do is flush out new information to short up their decision. If you're helping someone who's homeless and they get a minded to letter, you want to be picking that apart and treating it as if it's the final decision. You want to be raising issues robustly as you can to try and get them make a correct decision. But there is always a danger that you'll provide a really good argument that's right, and the council will still make a first decision. Sometimes it kind of doesn't work anyway, but that's just the kind of way that's the kind of way this process works. You've always got to fight at every level if you can. Prevention duty is owed to people who the council are satisfied they are threatened with homelessness and they are eligible. And essentially, it's just kind of this 56-day period where the council would try and prevent that person from becoming homeless. It can obviously depend, kind of on the varying circumstances, and also how much time the actual officer has to make kind of actions to prevent someone becoming homeless. It can be useful, I say. Obviously, it's worth making an application as soon as possible to maximise the amount of time you have to prevent yourself from becoming homeless or find an alternative accommodation. But I think a lot of the time, realistically, the prevention duty will just roll on and you'll actually become homeless, and then the relief duty kicks in, which is when the council's satisfied you are in fact homeless now and you're eligible for assistance. So no, there's no need to be in priority needs. That involves, both those stages involve a personalised housing plan being created. Personally, I don't believe they're worth the paper they're written on, but I appreciate will probably differ on that because you can use them. You see a lot of perverse situations when the personalised housing plan identifies very clear care and support needs or health issues, and yet the council simultaneously maintaining that they're not in priority need. So I don't know, it just seems a bit bizarre sometimes. But you probably can use the PHP in some circumstances to make a good argument, and if nothing else, just attack the council's position on the fact they didn't make adequate inquiries. So it might be, for example, the PHP doesn't include the kids' disabilities when it actually has to be a legitimate PHP. So yeah, and again, they're templates, So again, I've not really seen a useful PHP, and I'm sure housing officers resent the fact they've got to do them because they are just a bit of a tick box exercise most of the time.
Can I just add, Mike, that the personal housing plan is the descendant of the creature that we talked about earlier, or Mike talked about earlier, that the duty to give advice under Housing Act 1996, because the way in which the duty to give advice was generally discharged was saying something along the lines of, here's a list of estate agents and there's the door, so off you go, and hope you enjoyed that advice, which was no use at all, and it wasn't based on any assessment of the person's needs. So although the personal housing plan is far from ideal, it does improve on things because the council now have to keep a record that they've actually sat down and thought about what the person might need advice and help with. And it does give you an extra weapon if they're getting it wrong, whereas before it was just anecdotal. So it's, you get advice, sorry, there's a housing shortage. Not much more than that.
So a term that ties in with the relief, it ties in with the PHP, is the idea that you've unreasonably and deliberately refused to cooperate with it. It's quite a convoluted process for a council to reach that decision. But in effect, you'll have a situation where a council set out some steps and that person then doesn't, kind of unreasonably and persistently doesn't then comply with them. I don't think it happens that much in practice because I think a lot of housing officers, it's a lot of work to kind of go through that rigmarole. You've got to warn people first. It's probably easy just to let the relief duty end, just kind of roll on and kind of finish, and basically not have to worry about it. But it's something that applicants need to be aware of. They need to actually kind of genuinely engage with the steps that which are set out, as long as they're reasonable. Suitability is a very, very important and very, very complicated subject around homelessness applications. Essentially, any accommodation that a council provides must be suitable. But and that, as this slide says, it kind of takes into account the size of the property, the type of the property, are there stairs, how close is the property to essential things like schools and work and stuff like that. The law itself is it's good in the sense that, generally speaking, it seems pretty fair. The problem you've got with it is so complicated that it's actually quite difficult for a lay person to successfully argue unsuitability, and so. Yeah, again, it's something which, if you're in that situation, you definitely want to be reaching for, kind of local solicitor or any solicitor really that can help you out of that situation, because the arguments that a property is unsuitable get quite technical quite quickly. And again, it's kind of more. It's often about the process. Were the right things incorporated into the assessment of suitability, rather than is it objectively suitable itself. So there's a really good case called YR v Lambeth, as in the letters YR v Lambeth, which is worth checking out, particularly if you search for it on the Nearly Legal website, which is a blog done by Giles Peaker. Reasonable preference is quite a more broader term, but in terms of homelessness, everyone who is homeless gets something called reasonable preference on the housing register, and what that basically means is even if you're not in priority need and you are intentionally homeless, you still have to be put on the housing register, even if it's at the very lowest band. And I appreciate in many areas that's going to be useless; it won't be worth anything. But in some areas, actually, it can still result in someone getting social housing. So there are other kind of ways in which you get reasonable preference, but being homeless is one of them. And then staying within relief and prevention duties for a moment, there are various offers of accommodation you can get in those periods. The first is what I call informal offers. Now, this is not a piece of jargon because there is no word for it within legislation, but effectively, an informal offer is any offer of accommodation that isn't a formal offer, if you think of it like that. I'll talk about them in a minute. These will often be offers of accommodation in supported accommodation or rogue landlord accommodation, those kinds of things. And crucially, if you reject an informal offer, it has no bearing on the homeless application. Whereas if you reject a formal offer, either a final accommodation offer or a final Part 6 offer, then there can be some pretty serious negative impacts, as in the council might end all their duties to you. There's a video I did about this called "Can you refuse or can you reject an offer from the council?" Something like that. But you need to know the kind of the small print of this sort of stuff to see how it works. But effectively, a final accommodation offer is an offer of accommodation in the private rented sector, and a final Part 6 offer is an offer of social housing. You've also got the main housing duty, which is slightly different from the final Part 6 offer, although it looks the same for all intents and purposes. And that is where a council has decided that you are homeless, you are eligible, you are in priority need, you're not intentionally homeless, and local connections taken care of. That is essentially the best duty you can get, and that is when the council is going to provide you with decent quality private rented accommodation or social housing at some point. There's a lot of detail you need to know within these slides here if you're going to help someone out in the situation. So do check out that video on the YouTube channel because it goes into that detail. As I say, if you get it wrong, you can end up rejecting an offer of accommodation, which then results in everything finishing, which is obviously to be avoided. Within the homeless application process as well, you've also got rent deposit schemes and rent bond schemes. And they're not statutory things, basically. They're not legal things, but councils will use these schemes to increase the housing options they have available. And so you might make a homeless application and you think you're going to be owed the main duty because you're in priority need and you're not intentionally homeless, but a council may well use a rent deposit scheme to provide suitable accommodation as a final accommodation offer much earlier in the process. And again, is what it is. It's not I appreciate some people will be disappointed by that because they were looking for social housing for obvious reasons, but ultimately you need to engage with that, and you can't really refuse a lot of those offers in many circumstances. So but yeah, you might hear that, as I say, you kind of hear of these schemes. They can be used for people who are not in priority need as well. So they can be used just for, just kind of almost a little bit of kind of luck of the draw. You turn up one day, there happens to be a rent deposit scheme property available, and you might get put forward for it, and you might get housed. And then the next day, the next person doesn't get housed because there's no options. Discretionary housing payments, DHPs, basically a budget that councils have. It's not the only budget that councils have, but they have a budget called a DHP budget, which can be used to get good solutions for people to kind of ultimately save the council money in the long run. So there will be situations where someone has £2,000 worth of rent arrears and that's preventing them from being housed and they're stuck in temporary accommodation. The council may use a DHP to pay off the rent arrears so that that person can then get housed and therefore save them money in the long run. So there are lots of other situations that can be used as well. But there will also probably be other budgets like something like a spend to save budget, which isn't a DHP, which can also be used. So, as I say, if it's in the council's interest to help you because you're costing them money, you'll be surprised what they'll do. I've seen £5,000 of rent arrears cleared before because it's in the council's interest to do it. So this is why it's kind of worth getting into it with the homeless application process, and wherever possible showing that people are in priority need and they're not intentionally homeless. Because if you can do those two things, the council's going to have to house them, and that opens up other opportunities they might have to kind of help that person or that family out. So that's all the Part 7 terms. As I say, there's probably things we've missed. But if we get into Part 6 now, which is thankfully not as long, go back to the Housing Act 1996. Part 6 is the other part which matters, but it applies to anyone who is not homeless. So if you apply under Part 6, but you're homeless, you should be dealt with under Part 7 by default. But effectively, Part 6 is all about council housing, aka social housing, and weirdly can sometimes include, well, it gets a bit interesting with social housing that's been provided through things like Rightmove. So in fact, I'll leave that for the time being. But let's just kind of focus on council housing and social housing. So this is, as a general rule, much more affordable than private rented accommodation. As a rule, it's much more secure, although obviously Section 21s will not exist in 6 months' time, so I'm not quite sure what difference that'll make. As in, presumably private rented accommodation will be more secure. Generally won't be furnished, generally won't have even things like carpet, but ultimately, if you keep your nose clean, it's probably going to be a lifetime tenancy in effect, although technically it won't be that. As long as you kind of comply with the rules of the tenancy, it's likely you're going to remain in that home as long as you want to, really. So yeah, many reasons why it's better than private rented accommodation. And effectively, Part 6 is kind of what it dictates how the council should manage its waiting list, its housing register. So councils have a fair amount of discretion about how they kind of set their own rules for this, because Part 6 is essentially locally set, whereas Part 7 is nationally set. That's probably a good way to sort of see it. So every area will have a different definition of local connection under Part 6, but they'll all have the same definition of local connection under Part 7. And yes, that is ridiculously complicated even in itself, but that's kind of what I'm trying to say. And in effect, the housing registry is how people can apply for social housing who are not homeless. The direction of travel, it has to be said, I'm seeing increasing numbers of councils essentially not allowing people onto the housing register unless they're homeless. Effectively, I say that because I'm seeing Bedford at the moment, where I live, that in their housing allocation consultation, I think they're looking at just basically scrapping general kind of Part 6 applicants. I don't even know if that's legal or not, but I assume it is. But effectively, there is kind of layers of prioritisation for people. So if you, let's say you're living in accommodation, you're not technically homeless, but you're overcrowded, you would get a certain number of points or a certain amount of priority on the housing register. And so different councils will have completely different systems. You might have a kind of gold, silver, bronze band A, band D, whatever, or it might be you just got pure priority points or something. Some councils still use that kind of system, but it's effectively there to, in theory, make sure that social housing is allocated fairly and consistently. But it does get very complicated a lot of the time. And again, these kind of ideas of housing needs, medical priority, banding, priority points. Notice we're not here talking about priority need at all, because that's a Part 7 definition. But these are the kind of rules that the council sets. And so things like veterans, for example, will often get the highest priority banding under Part 6. Particularly medical conditions, people subject to abuse will often get the highest banding under Part 6. It gets really weird and I would say incoherent, because legally speaking, if you're subject to domestic abuse in your home, you should be dealt with under Part 7 anyway. So how councils have policies which basically, in a sense, incentivize people to remain in their own homes whilst being abused, rather than making a homes application. I don't know how that works, but it does. It's quite common. But you can see how how convoluted we're getting already without even really getting into it. In theory, every area has its own policy, which you can just Google. So if you Google your council's name and the term housing allocation scheme, you'll get your local policy. And in effect, if you're working in one area, you really need to know that policy. You need to have read it probably in a fair amount of depth. It's probably 30 or 50 pages long. But that will include things like how is banding allocated, who is excluded from the register. For example, it might exclude people who've got a history of antisocial behaviour for a certain number of years. All of those kind of little nuts and bolts you need to be familiar with if you're kind of going to help people access it. An allocation is simply where a council allocates, say, a unit of social housing in effect. So again, it's just kind of another bit of jargon which can make it sound more complicated than it really is. But the allocation policy just defines how that accommodation is allocated, and when it does so, it's called an allocation. So we just talked about that. On the housing register, generally speaking, there will be three categories of people. There will be people who are homeless and have been dealt with under the Part 7 route already, and the main duty has been accepted, or they're getting reasonable preference anyway. And so as an example, a few years ago in Bedford, it was 33%, 33%, 33%. So 33% of properties will be given out to homeless applicants, 33% to those transferring, and so on. That led to a huge bottleneck in temporary accommodation in Bedford. So they've upped the quota up to like 40%, but they're probably going to go higher, because that kind of defines how many people in those categories will get housed, and therefore defines how kind of long the waiting list will be for each category. As I say, I think we're going to see more and more councils basically scrap this quota altogether, and so that unless you're actually homeless or unless you're transferring, you're not going to get a house through the housing register. So Part 6 application, as I say, is generally speaking, when you go on the council's website and it says, do you need social housing? And you say, yeah, you click on a button and it takes you through to an online form. That is generally that simple. You'll have to provide documentation and stuff to kind of prove bits and pieces down the line. But as I say, it's important to understand that if you identify yourself as homeless in some way, and that might be something as simple as saying that you're subject to domestic abuse, and therefore legally you would be homeless. If you give that information in the Part 6 application, it should be dealt with under Part 7. If you want to see more about that, go to 18.6 of the Code of Guidance, because it explains just how important it is that councils pick up on that situation when it happens. Choice-based lettings is I don't know how much the country uses this term. I think pretty much everywhere does. I don't want to say every council, because it might not be every council, but I think certainly most councils have some kind of system which allows people to view properties that are coming up on the housing register and bid for them. Not in the sense that they're going to bid money for them, but express interest in it, and then that property will then be allocated to the person with the highest priority who's been on the housing register for the longest, effectively. Again, the direction of travel is to have less and less choice. So we're seeing more and more direct lets where basically someone doesn't get any choice at all. The council says you're going there, it's suitable, off you go, see you later. Whereas probably areas where they have less demand on housing, you probably do get more choice. But there will be something in the housing allocation scheme which probably sets out how long you can keep bidding for without winning a bid. So again, Bedford is an example. I'm pretty sure these days, if you bid on 3 bidding cycles which last a week each time, and you don't get anywhere successfully, you can just get basically you get put on auto bid, which is again this kind of idea of a direct let where you just get told where you're going to go and there's no say. Local connection, as I've said already, is different under Part 6 and Part 7, and Part 6 is locally set, so it's always going to be different. And effectively, as a general rule of thumb, the closer you get to London, the higher the amount, or the longer the amount of time you need to live there to get local connection. So the 2 worst councils in England for local connection under Part 6 are Hillingdon and Dacorum, where you need to have lived there for 10 years to get a local connection. Whereas if you're homeless, you should be dealt with under the homeless application route, and you only need to live there for 6 months. There's a bit more to it than that, but essentially that's why it's so important that you identify correctly that the homeless application has been kind of followed, rather than just a generic Part 6 application. We've also got this kind of symmetrical idea to intentional homelessness within Part 6, which is this idea of knowingly worsening your housing situation. Quite a similar idea, really. It's designed to stop people queue jumping. So yeah, I mean, I'm not quite sure how much detail the guidance goes into in Part 6 and how much is locally set. But basically, the council obviously doesn't want people to abandon their home because they know they're going to get a higher priority. So if you are deemed to have knowingly worsened your situation, often you will either get the lowest priority or no priority at all, as in you won't even get on the register for a certain amount of time. Again, housing allocation scheme will set out how that all works. And then the final thing with kind of Part 6 is this idea of mutual exchange. Now, I have to say, I don't think I've ever met anyone who's ever actually successfully done this, but maybe I've just kind of got my head in the ground or something about it. But in theory, it's where 2 or more social tenants somewhere in the country agree to swap their homes, kind of with the landlord's permission. I think it's probably quite difficult in practice to do, because most people who want to move will want to move because the property is horrible or the neighbourhood's horrible. And so you've got situations where you're trying to swap with someone else and they probably don't want your property because for some reason it's not good enough. I appreciate when it comes to like overcrowding and stuff, it might be different, but that seems to be a barrier quite often in terms of actually making it work. So yeah, that's all we're going to cover today. As I say, it's tedious as hell, but I guess it's just stuff that matters, and I'm hoping that this kind of format just kind of help you just get a better understanding about some of these ideas.